Florida is officially an open carry state. This is after the First District Court of Appeals ruled that the Florida State Statute 790.053 that prohibits the open carry of firearms is unconstitutional under the Bruen analysis. That's the histories and tradition test. McDaniels was open carrying a firearm as he was walking through the city of Pensacola and carrying a copy of the Constitution. He was arrested and then challenged the arrest under the new Supreme Court ruling.
Thank you, Your Honor. Eric Friday on behalf of Stanley McDaniels. Your Honor, as the U.S. Supreme Court stated in Bruen, it is the balance struck by the traditions of the American people that demands this court's unqualified deference, not a 1987 legislative enactment. The Florida Supreme Court's 2017 analytical methodology in Norman was expressly rejected by the Bruen Court. Norman cannot stand and is not binding precedent given the rejection of its analytical methodology. At the time Stanley McDaniels was arrested, Florida's firearm regulatory scheme, including its ban on open carry, operated to completely ban the lawful carry of firearms both inside and outside the home, except as a licensed privilege to carry a concealed handgun or an affirmative defense.
Everyone agrees that the law is active and in place. That's not in question. The legislature is going to be working frantically to come up with legislation that will address all the open carry concerns and where people can and cannot carry. It's all going to have to satisfy that Bruen-based analysis, and the state of Florida is going to have to show a history or tradition on any prohibition that they want to put into place. In the meantime, Florida's Attorney General put out guidance to the sheriffs and to everyone else suggesting that the prohibited places in 790.06 subsection 12A are prohibitive against open carry as well as concealed carry, and I don't agree with that at all. Now, I'm not suggesting you should go against the Attorney General's advice. Don't get yourself arrested. But this is a lot like the three-step rule. Just tell the people what the law is. We don't need to add extra stuff. 790.06 is specifically regarding concealed carry licenses. 790.0612A lists out the 15 different locations that your concealed carry license is no good. The only mention of open carry within the statute says that having a concealed carry license does not authorize you to carry openly in any of these places. It doesn't prohibit that behavior at all. That's a big difference. The truth is, there's very few laws that regulate the open carry of firearms while we're in this period of flux. You have 790.117, which prohibits the carrying of firearms at school-based events. You have several federal statutes that prohibit the carry of firearms. And you have American common law. What do they do back in the 17 and 1800s? So it doesn't mean that you're free to carry anywhere. There's still some limitations. But the Attorney General telling us that 790.0612A applies? Come on. The law is confusing enough. The people need to have clarity. When you muddy the waters with crap like that, it does nobody any good. Hit it hard.